Good morning, ladies and gentlemen. I welcome you all to another exciting experience today. We had our day one yesterday of ACL, and today we have day two. So ladies and gentlemen, please, can we put our hands together for this great experience for today?
In Africa, the prime causes of claims and disputes generally are change in scope, contract interpretation, and late design.
Dispute boards are not there to wait for, if you like, a dispute to happen. But the emphasis, they're there to ensure that claims don't actually come out disputes.
Construction companies tell their employees you have to keep records, you have to have minutes of meeting, take notes. It's hugely important because if you don't do that, you end up in a situation where you may be right, but you do not have the documentary evidence that you need to prove your case.
The concept of good faith is very strong in a civil law jurisdiction. Even though they sign in a common law contract with the idea that, parties will behave in a certain way, and that doesn't happen, then that's just going to cause problems.
The number one issue that I think we face as a facility is unprepared projects or ill-prepared projects is the biggest problem on the continent, at least in our experience.
In 2020, I received a call from Martins, our founder. And he had this idea to set up the Africa construction law. And so our primary objective at that time was to promote construction law as an area of practice and to promote an African network that included lawyers but was inclusive also of engineers and experts.
The judiciary is an essential part of all of this because we are here amongst ourselves, but at the end of the day, arbitration cannot be without the collaboration of the judiciary. In Nigeria, it's really a matter of commercial bargaining. I mean, most people tend to request for on-demand bond because of the problem associated with whether having to instigate litigation proceedings to demonstrate that you have a judgment in your favor, saying that there's actually been a default by the contractor and there's a court order to support that.
The authorities are more of the decisions between boards and whatever.
So at the end of the day, having separate jurisdiction, client selection, asset selection, contractors selection, and due diligence, very, very critical.
What I would put to the audience is that pulling performance bonds is extremely damaging because once you've pulled the performance bond, the credibility of that particular contractor or party gets completely destroyed.
So in our experience, what causes disputes? First, unclear contract terms. We also see desperation by contractors who underbid.
You need to ensure that the contractors that you bring into the project are the best that you can get. You ensure that you have a very robust and detailed technical scope. That technical scope, in essence, if it's done properly, you weed out those contractors who are not technically qualified.
You need to be represented and you need to get advice as the construction contract is progressing and when you see potential claims arising. But not only to get advice, but to choose your lawyers carefully.
You pick 5 disposition practitioners who are in the and you ask them, what is your preference? What do you do? They will be fair to say they do arbitration. But that doesn't take away the fact that mediation is effective.
Thank you. We're officially closing for the 2023 edition, and it was a fantastic experience. Thank you, everybody. Hope to see you next year.